Okay, well, we'll go ahead and get started now because it's a little bit after 8:30, I think, in Canada. So maybe we've got a smaller group today, but maybe that means that the ones who did attend can get some tailored advice from our IP specialists here. So welcome to the second webinar in our series of Canadian packaged foods. This webinar will be tackling how to protect your intellectual property. Sorry. Just having a technical issue with my PowerPoint. Okay, just a reminder to those of you who weren't here for our first webinar, this webinar series is being put on by the Trade Commissioner Service in China, specifically the Embassy of Canada to China in Beijing. The Greater China Network has more than 15 points of contact. So we have the embassy, we have 4 consulates, and then we have our CTO offices. Again, we're here to help Canadian companies gain market insight, connect with key contacts, find new opportunities, resolve business problems, and we're hoping to help you expand into new markets like China and reduce risks. So just another point is that we are always here to help you, so please feel free to contact us. You can contact our general mailing box at infocenterchinainternational.gc.ca. You can take a look at the China SME Gateway that has a lot of good information for Canadian companies in China or who are wanting to expand into China. And finally, if you have any questions about the webinar series or about other market development opportunities or promotions or trade shows, you can contact me, Amy Antonini, here as the Agriculture Market Development Lead in China. So with that, I'd like to introduce our speakers today. So we have Xiaozhen Zhao, who is a trade commissioner at the Embassy of Canada to China. She's a trade commissioner from the trade policy team covering IP protection at the Embassy of Canada to China. She helps Canadian companies understand China's IP protection system, including how to develop an IP protection strategy and deal with cases of IP infringement. Xiao Juan joined the Embassy of Canada in 2016. Prior to that, she worked for the Embassy of Netherlands in Beijing and Deheng Law Firm. She's qualified to practice law in the People's Republic of China. And we have Scott McLeod. Scott McLeod is the first Secretary of Trade Policy at the Embassy of Canada to China in Beijing, where his primary role is to lead on the intellectual property file. Prior to this, he spent 4 years posted at the High Commission of Canada to India in Delhi, where he was the lead on a variety of files, including trade policy, science, technology and innovation, and the Canadian Technology Accelerator Program. He holds a BA from the University of Calgary and a Juris Doctor from the University of Toronto. So with that, I will pass the parole over to Xiaojuan and Scott.
Hello, everyone. Am I visible, Amy, or?
Yep.
Okay. I can't see myself, so I'm not sure. Okay. So, yeah. So, as Amy mentioned, my name is Scott McLeod, and I'm a member of the trade policy team here at the Embassy of Canada to China in Beijing. I've been here for about 7 months, and within the trade policy team, I'm part of the IP team, which is myself and my colleague Xiao Zhuan. Just a very quick intro on our roles. You are familiar with the Trade Commissioner Service, and so I won't get into that too much. But in addition to our sort of business development roles and client service roles, which is this webinar would be a part of, and we do one-on-one direct interactions with clients. We also do cover IP policy. China's IP policy. So we monitor analyze regulations laws China and Canada. to just for their information to inform the advice that they give Canadian companies as well. So Xiaojuan has a very comprehensive presentation for you, and she'll go into a lot more detail, but I just want to make a couple of quick points off the top. Just a couple of points that I think are worth making and worth repeating, because I know Xiaojuan will touch on these as well. The first one of is the most important, I think, and that is if you are thinking about doing business now, or you're active in China, of course, you need to be thinking about IP. It's never too early to think about IP. As soon as you start to think that China might be a possibility for you, then you should be thinking about how you are going to deal with your IP in China and what your strategy will be and how you will protect it. And of course, once you are here, registering your IP is not the end of the story. You need to sort of be very sort of diligent and monitor and take steps to enforce your IP once it's registered. Registering it is not the end of the story. There's a lot of, and you need to evaluate your strategy and think about if it's working, what you're doing is working for you in the Chinese market. The second point is that it can, I believe, and coming from the outside before I came here, it can sort of seem like China's kind of a big complex market. Maybe the system is a little bit opaque and hard to understand, and there's language barriers and all that. So you might wonder if it's sort of it could be difficult or expensive to register your IP, and then even if it is registered, is it going to be force and protect that IP? And on that, and Xiaojuan will go into more detail again, but I just want to say yes. Over the last several years, the IP system in China is greatly modernized. It has improved significantly. It is not perfect. There are gaps, and there are challenges that will be encountered, but I don't think that any of that should be a deterrent to you thinking and taking steps to register and protect your IP. In China, it's actually not, the system overall is not that dissimilar to what you would find in Canada or the US. And to be honest, it's relatively straightforward most of the time. Again, it's not perfect, but you are far better off having your IP registered and protected here than not, because if you don't, and there is an infringement or there is an issue, the chances of you being able to do anything are zero or very close to zero. So with that, I will turn it over to Xiaojuan, and she will go into a lot more detail and give you a very comprehensive overview of how to protect your IP in China.
Yeah, thank you, Scott. Can you hear me and can you see me?
Yes, Xiaojuan, we can.
Yes, great. Thank you very much. Good morning, everyone. And as Scott and Amy introduced just now, I am Xiaojuan from the Trade Policy Department of the Embassy here in Beijing. And together with Scott, I'm covering the IP protection file here. Scott has already mentioned our job mainly includes two parts. The first one is following the IP development here in China and produce reports. And the second part, and which is actually the more important part of our job, is to help Canadian companies to understand the IP protection situation here, to provide related information, and also help Canadian companies to develop their IP protection strategy when they come into the Chinese market. Next slide, please. Normally when we talk to Canadian companies, most of the times our conversation will start by we start with these questions. For example, do I need to protect my IP in China if I already have my IP protected in Canada? Or do I is it possible to protect my IP in China? Or is it expensive to protect my IP in China? Most of the times, companies may think if their IP has already registered in Canada, maybe they don't need to take extra actions. However, IP rights, especially trademark rights and patent rights, they are both jurisdictional rights. So if you are coming to China and you want to protect your rights here, it's better to, it's important or it's necessary to register the IP here as well. Scott has already mentioned in the past years, China has made a lot of improvements in the IP protection field. On the one hand, all the laws and regulations, the IP related laws and regulations were updated, and those regulations or rules are most of the times in line with the international standards. And on the other hand, the enforcement situation was also greatly improved. And especially in recent years, the Chinese government received pressures from the outside to protect IP. And in the meantime, China is trying to transfer from the quantity-based economic growth pattern to the quality-based economic growth pattern. So IP protection is also an internal demand. So, so if you have the IP properly registered here, there is a very big chance to enforce the right here. For the expense to register the IP, I will go into that in later slides. But in general, the conclusion here is it is very necessary to protect your IP if you are bringing them to the Chinese market. And yes, it is possible to enforce your rights if they are properly registered here. Next slide, please. I can start with a few cases happened to other Canadian companies in the past and to show how important it is actually to have a proper IP protection strategy here. The first case is happened to a packaged food company. This company planned to sell in China through distributors. However, by doing the due diligence, the potential distributor actually rejected the cooperation because the company found out that the Canadian trademark has been registered by a Chinese firm in China. So the distributor didn't want to take the risk of being accused for the trademark infringement. The second case, this company came to us and asked what they could do. In this situation, the company can only either to remove the obstacle of the trademark, which means either they need to cancel or to invalidate the existing trademark, or they choose to use another name and repackage the products just for the Chinese market. But in either scenario, it's costly and time consuming. The second case is also about a packaged food company. This company had registration of their trademarks in China, but only covered the product of syrup. So their registration scope is very narrow. Later, when the company wanted to expand their business in the Chinese market and to sell syrup-related products, for example, the cookies or coffee, they found out that these products, the trademark on these products have been registered by others already. That means the company cannot sell those products in China with this trademark before they solve the trademark issue. And the third case is also happened to a Canadian company. It's a pet food company. This company has trademark registered properly in China, both in Chinese and in English languages. But later, the distributor of the company found out that products sold online which were not provided by the distributor or exclusive distributor were sold online. Then the company went to the platform, the e-commerce platform, and asked the platform to provide more information. By reading the information from the platform, the company found out actually the products sold online were also genuine products, but not the ones sold through their exclusive distributor, but imported from other markets. This is the so-called parallel import. In China, parallel import is legal. So actually the company or the platform sorry, cannot do too much on this. Next slide, please. Yeah, some companies ask us, how do I develop my IP strategy? Is there a sample or standard form that I can use? Our answer is IP protection is important, but it is just one part of your business development strategy. So when developing IP strategy, it should serve the business development strategy of your company. So the IP strategy is different from company to company. To develop an IP protection strategy, there are normally 3 steps involved here. Firstly, you need to understand what type of IP rights do you own. For example, if you are most of the companies here are agri-food companies today. Of course, the most valuable IP of your company should be your brand name or your trademark. But if you have any trade secrets involved in your products, then trade secret is another type of IP you need to protect. And if you have innovative design of the packaging, that is also one type of IP that can be protected. So when you develop the IP strategy, protection strategy, you should first identify what kinds of IP rights do you want to protect here. And the second, when you decided the scope or the rights you want to protect, then the second thing you may want to consider is why you need to protect those rights. For example, if you want to promote your products in your own name in this market, of course that you need to register your trademark here. And if you don't want the others to use the same trademark on similar products or on other products which can cause confusion, then you may take a preventive strategy and to register your trademark on those products which you may not sell in the market, but may cause confusion to consumers. So the second step is always to decide what is the purpose of registering this IP in China. Of course, the last step is to do the real registration. That will be further introduced in the next few slides. As Scott mentioned just now, to have a proper registration is just the first step. To sell in this market, you always need to maintain your your IP registration or the validity of your IP. First of all, you need to maintain the validity of your registration. Some of the companies, for example, the validity of trademark in China is 10 years. Some of the company, they register their trademark, but then they feel they are secured. They started to sell, but without noticing the end date of the valid registration. But after 10 years, the trademark expired. They were not aware of that fact. So it's always important to monitor the validity of your IP rights and to make sure it's always make sure to renew it before it's expired. The second thing you need to for the maintenance is to monitor the use of the IP rights in a market. For example, to monitor the use of the trademarks on e-commerce platforms. or by the service providers in the offline channels. That is always very important to find out the infringement at the earliest stage in order to minimize the loss. And of course, as we said just now, it is possible to enforce your rights here. The Chinese IP protection system provides several different enforcement options. For example, on all the e-commerce platforms actually provides notice and take down option for companies to fight against counterfeits on their platforms. And the companies can also report infringement to the local administration of market regulation as the administrative enforcement. The local authority can order the infringer to stop the infringement and also to confiscate the infringing goods. And of course, as the most common way to enforce the right is to bring the case to the court. If damage compensation is required in the enforcement, then to bring the case to the court or the judicial enforcement is the most favorable option. And China's customs also has an IP protection system. That means the China customs can enforce the rights of the IP holder at the Chinese border to stop the importing and exporting of infringing goods. Next slide, please. Yeah. Let's take a case as an example to see how others develop effective IP protection strategy for their Chinese market. This is an SME company, well, we can call it Company A. It's specialized in the sports nutrition products and wanted to explore the China market. They ensured that they engaged with a very good Chinese IP lawyer before they set their foot in the China market. They planned to attend the Canton Fair, which is the largest import and export fair here in China, to find potential Chinese distributors. Under the advice from the Chinese lawyer, this company ensured that they have registered their trademark in both Chinese and English languages in the first place. When they negotiate with potential distributors and develop distribution agreements, they have the agreement reviewed and revised by the Chinese Council. Their product packaging has been in the market for some time, so it cannot be registered as design patent in China due to lack of novelty. However, they revised their packaging specifically for China markets and have the revised version registered as design patent in China. They further registered copyright for the brochures and catalogs. As a result, the company has a very strong and layered protection of its IP in China, and thus minimize the cost of potential enforcement in the future. This company also monitors the online use of their brand name and take actions immediately once infringement is found. Next slide, please. On this slide, we compared the protection of Canada and China on most of the IP rights. From these two tables, we can see that the Canadian and the Chinese IP systems have a lot of similarities, but they also have differences. It's important to understand these differences in order to get proper protection in China. Trademarks and patents are jurisdictional rights, as I mentioned at the very beginning. So only the trademarks and the patents registered here in China or granted here in China will be protected here. Your registration in Canada, in the US, or even in Europe are not automatically protected here. And also, Hong Kong, Macau, and Taiwan are all considered as different jurisdictions when it comes to IP protection. So if you want to be protected in those markets, you also need to file separate registrations. Next, please. Because I guess most of or all of the companies here today are agri-food or packaged food companies. So our main focus of today's presentation will be on the trademark protection or the brand name protection, and also the protection of the packaging. If you have questions related to trade secret, patent, or copyright protection, please feel free to either ask during the Q&A session, or we can have a further discussion after this. For brand name protection, China applies first to file principle regarding the trademark registration. That means the Chinese Trademark Office, or it's called the China National Intellectual Property Administration, CNIPA, will approve the application of the person who files it first. No matter the market is, the trademark is in actual use or not yet, as long as the applicant can prove their intention of use, then it fulfills the requirement of registration. This is why there are so many trademarks which are not used by Chinese owners but have already been registered. With the amendment of the China's trademark law, the intention to use has been requested by the law. However, the order of filing the application still decides who will get the trademark. So if you haven't had your trademark registered in China, we strongly recommend you to start the process as early as possible. In the past, we always recommend companies which will come to China to register their brand names. But now we also recommend companies which may come to China in the future, or which even will not come to this market, to consider registering your trademark here, because that may also have impact to your overseas market, to your other markets. For example, if you don't have this trademark registered, have your trademark registered here, someone else register your trademark and exports the products to the markets where you don't have protection yet, then it's totally legal. You cannot stop them from exporting. Trademark protection in China is based on NIST classification. So there are in total 45 classes, including 33, I guess, products and 12 services classes. But what's unique in China is the subclass system. That means under each of the 45 classes, there are also subclasses, which are even more important, because the subclasses will decide the protection scope of the trademark registration here. One trademark can be registered by different companies under the same class, but covering different subclasses. So when filing applications, you should try to cover all the relevant classes and subclasses in order to get full protection. For companies which already have your trademarks registered in China, we also suggest you to review your registration and see if all the products you want to or in the future may sell to China are covered by all the subclasses. Both Chinese and English language trademarks are equally important, because Chinese consumers will use a Chinese name to identify a foreign product. If companies do not create their own Chinese language brand name, Chinese consumers will organically create one for them, which may or may not reflect the brand image. That also increases the risk of registering the Chinese name by the other party in bad faith. In practice, there are some Canadian companies that do not want to invest in the registration of their trademarks in the Chinese language. They leave it to the distributor or to the agent to register it, or just ignore the Chinese language mark. But at a later stage, when they break up with the distributor, they find out that they cannot use the Chinese name anymore because the distributors does not allow them to do so. Text trademark and picture trademarks are two different categories. Text trademark is the basic one. Everyone should try to register the text trademark if it is available. Logo can be protected by both copyright and trademark. If you can justify the logo is designed and used first by you, then it can be automatically protected by copyright law. But we still recommend you actually to register your logo if it is a specific design or unique design, in order to prevent the others from using it and save your time and cost, of course, to fight against the malicious use or registration. Next slide, please. In the past years, the China Trademark Office, or the CNIPA, continuously shortened the time of trademark application review. So currently, the official reviewing time is about 4 months, but including the application time and also the preliminary publication time. In total, it takes about 7 to 9 or to 12 months to complete one registration. That really depends on the complexity of the trademark. Foreign companies without a legal presence in China need to deal with the trademark issues through the China registered trademark lawyer. A decent firm normally charge about between 500 to 1,200 Canadian dollar to register one trademark under one class. Scott already mentioned at the very beginning, it is very important to find a qualified and experienced lawyer to help you, because these lawyers can do the more in-depth research before the application is submitted and maximize the chance of being approved. For example, last week, actually, we received an email from a client saying that their trademark application was rejected because it was similar to other trademarks. But if the lawyers of this company could do the more in-depth research before the application was submitted, this situation may be avoided. And also in the market, there are a lot of trademark agents charge very, very low price. For example, just a few hundred RMB to register one trademark for a company. But as I said, those companies may not do in-depth research. They just submit the application and wait for the result. After the application is rejected, then this company starts to make money. They will advise you to appeal and then to bring the case to the court. It takes several years to finalize the case, and the cost will be much more than hiring a qualified firm in the first place. And also a qualified firm has good reputations. They can advise you properly about the registration scope. A few months ago, actually, I heard from a Canadian company. The company told me he had spent more than 10,000 Canadian dollar on trademark registration because his lawyer advised him to cover all the classes, and which actually not that useful for a SME company. So it's important to have a good lawyer. Those lawyers can give you the proper advice to protect yourself fully, and in the meantime, to save your cost. Next slide, please. In recent years, e-commerce, especially the cross-border e-commerce, are now one of the major channels for Canadian companies, especially the consumer goods products companies, to enter into the Chinese market. So in this page, I'd like to share with you some common questions asked by the companies and also issues encountered by other companies. First of all, according to the policy to open a store on a cross-border e-commerce platform, that means the cross-border, not the domestic e-commerce platform, to hold a Chinese trademark is not a mandatory requirement. The platform only checks if you have a legally registered trademark outside China. That means if you want to open a shop on the Tmall Global or JD Worldwide, those type of cross-border e-commerce platform, you don't necessarily need a Chinese trademark certificate. Your registration certificate in Canada is already sufficient to fulfill the IP requirements of opening that store. But in practice, we still recommend companies to register your trademark in China because there are some potential risks. For example, if your trademark is registered by others on purpose to prevent you from using the trademark, or it's owned by others and accuse you for a trademark infringement. A few months ago, a Canadian nutritious company asked us if they can open a store on a cross-border e-commerce platform while another Chinese company owns their trademark in China. Whether there is any risk. We forwarded this question, although we know the answer already. We still forwarded this question to the IP department of Tmall Global, and the answer was that the answer we got from Tmall Global was that this has the risk of being complained and sued for IP infringement. So Tmall suggested the company to register the Chinese trademark or take other actions to get the trademark back. Once you have the trademark properly registered, the next issue needs your attention is the authorization of use by distributors. It is very important to agree with the distributor on the scope of the products and the ownership of the online store. Companies are recommended to monitor the use of the trademark online regularly. You can do that either by your Chinese-speaking staff, or you can also hire IP firm for that. A lot of companies, they offer the regular service and to help SMEs to monitor the use of their trademark online. Once the infringement is found, you can file complaints on the IP Protection Center of the platforms. The platforms can decide to remove the link or even close the shop of the infringers. However, there is one thing you need to pay attention. This service is free of charge and the English website is available. However, you need to make sure you are able to provide the evidence that the platform requests, or if you are not sure, you'd better consult a lawyer, a qualified lawyer who is familiar with the procedure to help you. We also had a Canadian furniture company came to us and complained that Tmall ignored their complaint of IP infringement. By communicating with Tmall, we understood that that issue was the rejection by Tmall to that complaint was the insufficient evidence the company provided. So, and also the company chose an inappropriate category of complaint when it filed the complaint. So the company the company went to a lawyer and worked with the lawyer and submitted the complaint again. It was well accepted by Tmall then. Next page, please. Just now what we discussed was the protection of trademark. And for some of the companies, you may have very special or unique design of your packaging and may have some question about how to protect it. Generally speaking, there are two rights can be registered about the packaging. First is copyright, and second is the design patent. Copyright is an automatic right. Once the work is completed, its copyright is protected. Examples of copyrightable works are the image of each product and also the brochures or the catalogs, the website content, the labels, and also various type of marketing materials. Copyright registration is voluntary here in China. Even if you don't register it, you still enjoy the protection. But in practice, the registration certificate is generally required or desired by the Chinese court or the administrative agencies in the enforcement cases. Therefore, registration is still recommended. And if you have a very specific design, especially the shape or the color of the packaging, design patent offers a stronger protection. Design patent can protect the shape, pattern, color, or their combination of a product. For example, some of the syrup companies have the bottle of the bottle in the shape of maple leaves. Those designs can be registered or protected by the design patent. But this design should be absolutely novel. Any previous use or the publication of a design within or outside China will destroy its patentability. So registration of a design patent is relatively inexpensive, and it can be completed within 1 year. If that is the special design and which you are going to use for a long time, design patent is effective tool to protect this packaging. Once the design patent is granted, the duration of protection in China is now extended to 15 years. It was 10 years before 2020. Next slide, please. On this page, I listed several common issues happened to Canadian companies. The most common type of issue is, of course, the preemptive registration by another person or entity of the trademark. This also can happen to patents, but today we mainly talk about trademark. The preemptive registration can be done, mainly be done in two ways. First type is registration by distributors or by agent without notifying the original trademark owner. That happened a lot in practice. Many of the Canadian companies, when they came to us and tell us the bad story, those stories were the registration by their distributors or former partners or former employees. That type of bad faith preemptive registration. The second type is preemptive registration by a totally stranger. With the development of e-commerce, it is very easy to get the information through the internet. So some of the companies, even had never been in contact with the trademark owner or with the product owner, they can still register the trademark in their own names. For example, a few years ago, there was a Canadian nutritious company came to us and told us that his trademark was registered by a trading company in Fujian province, which had never been in contact with them. And by searching the trademark database, we also found out that company registered in total 5 Canadian nutritious product trademarks, and those trademarks had never been in use. It's obvious that the trading company registered those trademarks to wait for the original trademark owner to approach them and to purchase them. To prevent those issue to prevent these things from happening, the most cost-effective or the most efficient way is to register your trademark in China as early as possible. The second type of case we heard a lot is the unsuccessful IP application or registration in China. In the cases of trademark registration, that mostly are trade rejections because of the because lack of distinctiveness. To register a mark to be qualified as a trademark has to be distinctive. The descriptive words cannot be registered as a trademark. For example, apple cannot be registered as the name of a fruit or a trademark of a fruit, although it can be registered as a trademark of electronic product, but it is since it's a generic name of a fruit, it cannot be registered like that. For example, companies, there was a company wants to register a name as Pure Skin. It was not successful because it was too descriptive. So before filing the trademark with the trademark the trademark authority, it's important to discuss with your lawyer and to ask your lawyer to help you evaluate the chance of being approved. The third type, of course, of common issue is, of course, the counterfeit products. For that, our advice would always be monitor the use of the trademark in the market and to find out the counterfeits at the earliest stage. Then take actions to enforce your registered rights here. Next slide, please. In the next two slides, I'd like to share with you two more cases on trademark registration and enforcement. This first one is about the trademark registration. This is happened to a small SME nutraceutical product company. We can call it Company A. It's not a Canadian company, but it's a foreign company. This company entered into the Chinese market by working with a distributor. When the relationship ended, Company A decided to file its own trademark in China. However, it found that the mark has been registered by a Hong Kong company already. The company then engaged a legal firm to get the trademark back. The legal firm did some investigation and found that a senior manager of the former distributor actually set up that Hong Kong shell company for the purpose of pirating Company A's brand name. Company A first wanted to buy the trademark back from that Hong Kong company or from that senior manager, but that company asked for a ridiculously high price. The Hong Kong company also filed online complaints on the e-commerce platforms in order to prevent this Company A to use its name or to sell products. Then the legal firm helped the company develop a plan to file trademark, developed a plan to use multiple tools to get this trademark back. Firstly, they filed a trademark 3 years non-use cancellation application. Then they appealed to the trademark office to invalidate the registered trademark of the Hong Kong company. And at the same time, it filed the new applications of the same trademark. At the end, this company achieved good results and it got their trademarks back. However, this company actually spent a few thousand US dollars on this case. But if it can register the trademark under its own name in the first place before he cooperates with that distributor, or at the beginning when he cooperates with the distributor, all those time and money he spent on this case can be saved. So this case tells us it's very, very important to start your registration as early as possible. Don't leave the registration to your distributor or to your partner to register your trademark. Next slide, please. Yeah, this second case is a enforcement case. This happened to a Canadian, also a nutraceutical company. This company entered into the Chinese market through a distributor, and later on, the company wanted to end the relationship and explore the market by himself. Then the company found out the distributor has filed the application of this company's trademarks in China. The lucky thing here is that application is still in the reviewing stage. So the company has the opportunity to oppose those registrations before it's officially registered. That distributor also opened a flagship store on Tmall Global in the name of the distributor. So the company needs to first stop the registration of the trademark and then to close the Tmall Global store and open it by himself. So with the help of lawyers, this company brought up opposition case against the trademark registration and also contacted Tmall to close the shop. By taking these actions, the company was able to disconnect with the distributor and launched his own shops on different platforms. And also a few days ago, we were informed that the company won the opposition cases, and now it is in the process of registering the trademarks in its own names. This case tells us, first of all, it's important to be the owner of your own brand and shops in China, especially especially when you open a shop on the e-commerce platform. You may need the assistance from the service providers, but it is very important to clarify in your cooperation agreement that you should be the owner of your e-commerce store, not the service provider. Secondly, the second lesson we can learn from this case is, even if you encounter those issues, don't be afraid of taking actions with the help of the IP experts. As I mentioned at the beginning, the IP enforcement environment has been improved a lot in the past years. It is possible to enforce your rights here, and sometimes to take the enforcement action itself already has deterrent effect on the infringers, and they may already stop the infringement by themselves. Next slide, please. Yeah, so this page just summarize the most important things we mentioned today. First of all, IP is a jurisdictional right. If you want to be protected in China, especially in mainland China, you need to register your IP here. Secondly, multi-layer IP protection strategy can provide you better protection. Thirdly, if unfortunately you encounter IP infringement issues here, don't be afraid of enforcing your rights. And last but not least, qualified lawyer with China experience will be very helpful to save your time and cost on your IP registration and IP enforcement. Next slide, please. As mentioned previously, Trade Commissioner Service can help you with the requests about IP protection in China. Here are the services we can offer. If you want to start your registration in China, but not sure about whether the name has been occupied, we can help you to check in the China trademark database and advise you on the next steps accordingly. If there are disputes happening, we normally provide information on resolution options based on Chinese laws and regulations. And of course, we also do awareness raising sessions like today's webinar, and to help companies understand Chinese IP protection system and common issues, and as well as the best practices of the others. Last, we also can help companies to connect with the qualified legal service providers for further actions. As a part of the Canadian government, we don't provide legal service, but we can connect you with the service providers, which have good reputations and helped other companies in the past. Next slide, please. This comes to the end of my presentation today. If you have any questions, or you have encountered any issues, or if you have any good story or lessons to share with us, please feel free to write to either Scott or myself or Amy, and we are always happy to be in contact. That's all. Thank you.
Thank you so much, Xiaozhuan and Scott. So right now, I guess we can take a few minutes if there's any questions. I can't see the chat box, so I'm going to rely on my colleagues to look at the chat box right now. If there's any questions in the chat, or if anybody wanted to ask a question, you can put up your hands and we can unmute you. Okay. I don't see any questions. Again, if you had any questions, yes, please reach out to me or Xiaozhuan or Scott or Josh Cater or Rachel Chung, who are also on my team. Just a reminder, we've got 2 more webinars in this series. We'll send out a recording of this webinar to everyone who registered for this webinar. And yeah, again, please reach out to us. We're always looking to help, and I can answer any questions that you have about the China market. So thanks, and have a great day.
Okay, bye.